Hey everyone, in this video we're covering Chapter 16, the writing requirement, also known as the Statute of Frauds. This topic explains when a contract must be in writing to be legally enforceable, what counts as valid writing, and the key exceptions to this rule. So, Section 1. The Statute of Frauds is a state law that requires a certain type of contracts to be in writing in order for them to be enforceable in court. The main purpose is to prevent fraud, misunderstandings, and false claims by requiring written proof of important agreements. If a contract falls under the Statute of Frauds and is not in writing, it is usually unenforceable. So, there are 5 main types of contracts that must be in writing. 1 is contracts involving leases and land. These include sales, leases, mortgages, or transfers of real estate. Because land is valuable and permanent, the law requires written evidence of the agreement. Next, we have contracts that cannot be performed within 1 year. If a contract cannot possibly be completed within 1 year from the day after it formed, it must be in writing. But it is even possible to finish within a year, then it does not need it to be in writing. Then we have the collateral promises. This is when someone promises to pay another person's debt if that person fails to pay. Example, if my friend doesn't pay for the car loan, I'll pay instead of them. These promises must be in writing unless the main purpose is personal benefit. So, we have next promises made in consideration of marriage. So these are agreements made because of marriage, such as prenuptial agreements, or also known as prenups, or financial promises tied to marriage. There must always be writing to be enforceable in these types of agreements. And the last type is the sale of goods that are worth more than $500. Under the UCC, also known as the Uniform Commercial Code, contracts for goods priced at $500 or more must be in writing. But the writing only needs to include the quantity of goods, not every single detail. Next, even if a contract should normally be in writing, there are 4 important exceptions where courts may still enforce it. 1, we have partial performance. If one party has already started performing the contract, a court may enforce it. This often shows that a real agreement likely existed. Then we have admissions. If a party admits in court that the contract exists, the contract may be enforced. However, it is usually enforced only to the extent admitted. Then we have promissory estoppel. If one party reasonably relies on a promise and suffers harm because of it, the court may enforce the agreement. This is used to prevent unfair results or injustice. Then we have the special UCC exceptions. In business transactions, custom-made goods may be enforceable even without writing, and written confirmations between merchants can also satisfy the rule. So, what counts as writing? A writing does not have to be a formal contract. It can be emails, texts, receipts, invoices, faxes, even multiple documents combined together. So, what must be included? Well, for writing to be valid, it must include the essential terms of the agreement, the names of the parties involved, the subject matter of the contract, key terms like quantity, especially for a goods contract, and it must be signed by the party being enforced against. Even a typed name can count as a signature. So, to summarize, the Statute of Frauds requires certain important contracts to be in writing, but there are exceptions where courts may still enforce oral agreements. Understanding what needs to be in writing and what doesn't is key to avoid legal issues in contract law. Thanks for watching and good luck studying. I'll see you next time.